And then choose the appropriate protections to protect the different aspects of that. So I'm going to give you information about that. Then you need to align your IP strategy with your business strategy and your development work. So intellectual property doesn't drive the business. It's kind of the other way around. The business should drive and determine what intellectual property you need. Then you have to assure that you have something called freedom to operate. And this means you're not going to get sued by someone else. That's very important, because if you start a business and of time and money only to find out that someone has a means to stop you from doing what you want to do, that wouldn't be a very good position to be in. So that's called freedom to operate. And finally, as an entrepreneur, you need to make sure you've developed some kind of a risk management plan, because every business and every venture comes with some various kinds of risks. So we'll talk a little bit about those if you want to as well. But I'm going to spend the first few slides before we start answering questions, first few minutes, talking about the different kinds of intellectual property, because a lot of times people mix them up. They use the words interchangeably. And I want to kind of set the stage so we know the distinctions. But to begin with, intellectual property is a product of the mind. It's the things that we think up, our human intellect. But there's no real way to protect a pure idea. For it to be legally protected, there needs to be some tangible manifestation of that idea. And as I said, there are various instruments available to you to protect your IP, depending on what the product is or your business goals. And the forms of IP that I'm about to talk about are not necessarily mutually exclusive, meaning you don't just pick one and you're done with it. You may be able to use all four of them, or use them in different combinations. And that can help maximize the protection you have. But it depends on your business and your product and your business goals. So let's start out with the first one. The first kind of protection that you could legally have is protection for something called trade secrets. So a trade secret is some information that you have that provides you with some economic value because you're keeping it secret. So, for instance, the most commonly, I'd say, known trade secret, but it's not the secret that's known, but is like the formula for Coca-Cola. Nobody knows what that formula is. And Coca-Cola guards that very carefully. Only a few people know. And they derive a lot of value because the competitors don't make exactly Coca-Cola. And another example is like the herbs and spices in the Colonel's chicken. the exact mixture of spices is a trade secret. No one knows. Only a few people know exactly what those are. But it doesn't have to be as exotic as that. It might be an algorithm that you have that you use to predict some outcome, and people pay you for those predictions, but you don't want them to know what that algorithm is. So you take steps to protect that behind a firewall. You don't give them a copy of a program that they can reverse engineer that has the algorithm in it. And you get this legal recourse against people that might misappropriate or otherwise steal your trade secret for as long as you take reasonable efforts to maintain the secrecy of that information. So trade secret laws are governed by state law. Every state has its own trade secret laws, but they're also governed by federal law. So there's now this Defend Trade Secrets Act that came about in 2016. So people have some very useful legal tools to go after people who steal trade secrets. So there's an example of a person who worked at Uber, and they were working on self-driving cars. And when he left, he took some of that information with him. How did they know? Well, he was accessing computer files and downloading that information to his own little thumb drive, and companies know when you are downloading information from the servers, and if it's proprietary information, then they might come after you and prosecute you for theft of trade secrets. So we talk about what are reasonable efforts, and this is some. So first of all, if you have some secret sauce or secret formula or a way of doing something that nobody knows about, you don't want to tell people about it right away or publicize it. And if you do need to discuss it with someone, you want to put something in place called a non-disclosure agreement. It's an agreement that they sign that says they won't do anything with that information that you've given them. Very often, there's a limited period of time for that information. Maybe it specifies that you gave it to them to evaluate your business, but they can't use it commercially. And then if they were to go ahead and do that, you would have recourse in a court of law to go after them. Now, going after them can become very expensive, and you may not have the financial means to go after them, but at least you would have the legal grounds in place to do that. And I mentioned some other ways. In companies, they have physical security for access to buildings and information, passwords on servers so that everybody can't read everything, things like that. And those are reasonable efforts. We don't throw confidential information in the regular trash, right? We make sure it gets shredded, things like that. So those are reasonable efforts to keep it secret. And if you were to sue someone, it would come down to what were the reasonable efforts that you took. So you would have to have demonstrated that. So the next piece of intellectual property I'd like to talk about are called patents. And patents are sort of the opposite of a trade secret. And what a patent will give you is the right to stop other people from making, using, or selling the invention that you've patented. And there are different kinds of patents. The most common kind, when people say, oh, I have a patent for something, they're referring to something called a utility patent. But you can also get a patent on the design of something, the way it looks, not just the way it works, which is what a utility patent does. And a third category that most people don't use are called plant patents, and it has to do with asexually reproduced plants, not genetically engineered crops, but plants that are bred in different ways. And you get the right to stop others from doing things from the government. You get it for a limited period of time in exchange for telling everyone how to make and use your invention. So that's sort of the opposite of a trade secret, where you don't tell people how your invention works. In a patent, you tell everyone, and then you get 20 years of protection to stop them. Now, stopping them may become expensive, but that's what a patent will grant you. So to qualify for a patent, now to qualify for a trade secret, it's just something you keep secret. You don't register it, you don't declare it, you don't have to necessarily write it down anywhere. There's no federal registration involved. But for a patent, then, you actually have to go through a registration examination process at the patent office. So to qualify for a patent, you have to meet some legal requirements. First of all, it has to be something that is patentable. And the statute, the law, lists the kinds of things that are patentable. And up to maybe 10 years ago, we thought just about everything was patentable, but then we began to find out that may not really be the case. And in the United States, it's getting harder and harder to patent certain kinds of things. And your invention needs to have some kind of a use, which doesn't mean it has to work, but you have to know what the use of your invention is. It has to be novel, which means it has to be something that no one's ever done before or described in a publication or put into use. And then it's got to be something that is really kind of hard to quantify. It has to be something that's not obvious. And what that means is not obvious to somebody who is skilled in the field of your invention. And that's the area where you spend most of the time arguing with the patent is obvious. You get the protection for a period of 20 years in general from when you file, but it's complicated because there are lots of things that affect the actual length of your patent term. Now, I'm not going to go into that right now, but you also need to know that patents are geographical in nature. So if you want protection in the United States, you apply in the United States. If you want protection in other countries, you have to apply in all of those countries, which can get very expensive if you think about protecting an invention all around the world. But you don't necessarily need protection in every country. First of all, maybe the United States is a big enough market, and you don't care if someone copies and sells your invention outside the United States. Maybe the United States and some European countries are enough, and you don't care if someone sells it in Australia. But you would need to decide what countries. And the more countries you have, the more expensive it would become. There is no one worldwide patent. Okay, the third area of intellectual property is called trademarks. So trademarks can also be thought of as the brand that you have for your product or service. And trademark law is in place to protect consumers from becoming confused as to the source of the goods or services. Because if the names of the companies are confusing, or the names of the products are confusingly similar, then the consumer will say, well, how do I know which product is which? I may not be able to tell them apart. And that can easily happen, especially if they look the same and sound the same. A consumer might be confused. But companies use trademark protection to protect the integrity of the brand so that people know what they're buying, and sometimes even prestige is built into the brand. So everyone wants an Apple computer, or everybody wants Nike Air Nike shoes. Nobody wants the generic brand of something, or very often, so people identify with the brands sometimes for some products, and for other products, no, they don't care. They want the best value and price, and yet they identify that by the trademark that's on the product. So trademarks are not awarded based on the creativity of the name or anything like that. They're awarded on the first user of the name or the logo in commerce for a particular product or service. And then you can move ahead with registration as long as your mark that you're choosing isn't confusingly similar to one that someone else chooses. And unlike patents, trademarks, as long as you keep using them, never expire. You need to pay a renewal fee, and you need to certify to the trademark office that you're still using them, but they do not expire. So there are trademarks that have been around for more than 100 years, and Coca-Cola's been around for more than 100 years. You can think of many brands that have been around for a very, very long time. There are state trademarks and there are federal trademarks, as well as trademarks in other countries. So trademark law is also geographic. If you're only selling your product or service in your state, the state of Washington, then you would want to register at the state level. If you're selling interstate across the country, then you could register at the U.S. Trademark Office. And if you do that and the mark is granted, you can put the little R in a circle next to your trademark. And if you want protection outside the United States, you need to register your mark in each of the countries of interest. Although there are some regional registration processes that make it a little easier and perhaps a little less expensive, you still need to area where you would want that brand registered. And the fourth area that I'll mention is copyrights. So copyrights protect original works of authorship fixed in some tangible form. So it's got to be either written or recorded in some way, or it could be an MP3 file, which is recorded in a way, even though you can't read it, a machine can read it, that's all right. So computer code can be copyrighted, and they are based on originality to the author. So if we all went down to the the coast and took a picture of the sunset over the ocean, we would all have the copyright on our own photographs. Now, those photographs might all look pretty much the same, and so the value, let's say, of selling those photographs may not be very high, and the strength of the copyright may not be much because all of our photographs might look the same, but one of us, would have more creativity. I would say one of you, because I'm not a great photographer. And the photo would have, there'd be a boat or a bird or something in the scene that would make it just beautiful. And you might actually be able to sell that photograph, right? And you would have the copyright. And if somebody were to copy that photograph, then you would be able to go after them for copyright infringement. Now, copyrights attach to the work when you create them. You don't have to register the copyright, but if you want to sue someone or be able to defend the copyright in federal court, which is where you would have to do it, then you would have to register it at the Copyright Office. And copyrights last for the life of the author plus 70 years. So they will outlive you, and your estate then would be able to enjoy royalties from the copyright. So if you're an author, the estate of the authors still enjoy royalties from the sales of the books and things that may be covered by copyrights, or the movies or the music that was created. But eventually the IP rights expire, and then that work can fall into the public domain. So some things aren't protectable by copyright. And I want to bring this up because people often confuse copyrights and trademarks. So things like titles and names and short phrases, slogans, those cannot be copyrighted, but may be eligible for a trademark if they identify the source of the goods or services. And ideas and procedures and methods, things like that, those would fall under patents. And it's also important to know that works that consist of, facts and commonly known information are not copyrightable. So you can't copyright, the map of the world. Although you'll see, if you buy a map in the corner, there'll be a little copyright. And what that refers to is the way it's presented. So maybe it's the colors that were used or some other information presented on it. but you can't copyright a diagram of the borders between states or countries because that's just a fact. And similarly, in an almanac, there are tables of, or on the internet, in a digital almanac, there are tables of information. And that information itself is not copyrighted, but perhaps the arrangement of that information might be subject to copyright. And so when you're copying things off of the internet, you need to be very careful, because just because you can view it and you can right-click Save As and download it onto your disk doesn't mean that you have the rights to that information. So if you save a photo off the internet that you want to use on your website, that photo may be copyrighted by someone else, and you may not have the rights to use it. They may come after you for having you put it on your website. That would be an example of lack of freedom to operate, where you didn't have the rights to use that information. So we have the 4 forms of intellectual property. We have trade secrets for information that you want to have an advantage over others because you keep it secret, a process or the formula or algorithm or just the knowledge that you have. We have patents. We have a process that perhaps people would be able to figure out, or maybe it's a device that once you sell it, they could reverse engineer it and start copying it. So you want to have a patent on it to stop them from doing it. We have trademarks, which represent your brand, your logo, your identity. And we have copyrights for the artistic creations and things like that. So I'm going to pause here and stop sharing my screen and hopefully not hang up. And just open it up to people's questions or things that you might want to know about.
That's great. Thank you so much for this presentation. It was awesome. So, everybody saw the chat. So please put your questions into the chat if you have any. So we open it up for Q&A right now. And while you think, we have some questions that we prepared as a club too that we can answer prior to your questions, so you could have some time to think about it. So I think I want to start with, of course, thank you, Bernard, for coming to this meeting today to talk to us and to present your ideas about intellectual property and how can we protect it as entrepreneurs. And I actually have a couple of questions about that. First of all is, of course, we're noticing the huge advancement in technology that are happening right now at the beginning of the 21st century. And my question is, how do you see intellectual properties changing in correlation with new technology? Like, maybe, is there any technology that surprises you and makes you think that it can change the way intellectual property are perceived, done, or maybe used in the future?
Yeah. Well, you have to realize that the laws around intellectual property have been around for a very, very long time, although they've evolved. And intellectual property patents specifically are there to protect inventions, new inventions. One of the leading edge areas in high tech is artificial intelligence. And the courts, the judges in the courts, are pretty far behind in understanding how the evolution of computers is kind of taking over intellectual property. So, for instance, if a computer is solving a problem, is that really is that really an invention? Because computers are inventions, but computers are made to do things. And so when we say a computer can solve, here's a patent on using a computer to solve a problem, they say, no, that's an abstract idea and it's not patentable. Although in other countries it is. So it's getting the patent office to understand how to patent artificial intelligence inventions has become very, very difficult. on the biology side of things in life sciences, where I practice mostly, then we use computers and algorithms and things to diagnose diseases. And we say if we measure a bunch of things in a person, we measure their genetic makeup, we measure different proteins in the blood, and we correlate those things to say this person is prone to contracting a disease 5 or 10 years from now, or maybe even being able to diagnose the disease they have. The patent office says, well, that's naturally occurring, and really you haven't invented anything. So it's very hard to patent that. So I see that in the US, patent law hasn't caught up with technology yet. And what that's done is for diagnostic companies, and what it's done for a lot of artificial intelligence based companies, is to drive that all into trade secrets. So we don't tell people how we do the diagnosis. We just say, send us a blood sample and we'll tell you the answer. But we won't explain to you how we've come about to do that. And the risk is they'll figure it out on their own, but it's expensive.
Thank you so much for answering my question. We have some questions in the chat, so let's start with question of Jay. Jay asks, Bernard, what do you think about IP of NFTs?
Yeah, so non-fungible tokens, right? So the first thing I would ask is, does everybody understand what those words even mean? When we say something is fungible, do you understand what that term even means? It's important. It's important. So the fungible means exchangeable. So let's think about these non-fungible tokens. We just heard about this for a sale of some artwork, right? For millions and millions of dollars. It was a non-fungible token and it was auctioned off. So non-fungible tokens, something is fungible if it's exchangeable. So Bitcoin is a fungible currency, right? You can exchange this token that it lives in a computer. You can exchange that for real dollars at some point. But a non-fungible token is something you can't exchange for anything. It's non-fungible. It's not exchangeable. And what happened was this artist took thousands of creations that he had, pieces of artwork, and he digitized all of them. And then he created a token, not unlike a Bitcoin, which is tracked, in cyberspace. And the token is a certificate of authenticity for that artwork. And somebody bought it. Now, they really didn't get the rights to all of those pieces of art, right? They don't own all of those pieces of art. They own the digital token that has to do with those art. So I'm not sure how they arrive at the value. It's because he's a famous artist, right? And people aren't even sure, right? When people speculate in Bitcoin, people are speculating in these non-fungible tokens. But let's say you painted a painting and you thought it had a lot of value. You could create a non-fungible token for that painting and then auction it off, and someone would buy that digital certificate of authenticity for that painting. And it would ostensibly now be in their possession. But they wouldn't have the rights to make more of them or something like that. They would only have the rights to view that painting that you gave them with the NFT. So I don't know quite what to make of it. Although I'll admit I was sort of tipped off that some people were interested in this category, and I'm going to post in the chat an interesting article I found that you might want to read. It's from a law firm, and it discusses lots of aspects of NFTs. So later on, you might want to go to that website and read that article.
All right.
Wouldn't it be cool if the Mona Lisa was for sale as an NFT? Yeah, that would be interesting, but I don't think the museum wants to do that, right?
I wouldn't want, if I were this museum, I would have not wanted to do that totally. Well, okay, so we have some more questions in the chat. So Ramon asks, what's the most appropriate way to establish intellectual property on a grant created by a public and private institution? Example, a grant by UDAP in collaboration with Microsoft or any other private company.
Okay, so if you have a grant, then there will be terms and conditions in the grant. So for instance, researchers who are in universities who are federally funded, the grant from the US government allows them under the Bayh-Dole Act to file for patent protection or intellectual property protection. And then the contract with the university and the terms and conditions of the grant, the university may have certain rights to the work that you do there as an employee or as a student with their facilities. And the government from the grant has access to your intellectual property as well, although they rarely take it. But if you discovered, let's say you discovered a cure for COVID-19, you see the government could come in if they wanted to and force you to give them the rights to, scale that up. But as we've seen, the government even had rights to not to Pfizer, but I think Moderna or some of the other companies. They funded a lot of the vaccine effort, but they didn't march in because the companies stepped up. The companies don't want the government to come in and take over their intellectual property. Now, if you have a university and a company and other things, you have to negotiate those terms and conditions that says, well, what rights do I get? Yeah, I'm the inventor and my name goes on the patent, but, if it gets commercialized, do I get any royalties? Or something like that. Most of the time when you work for a company, yes, you get your name on the patent if you're an inventor because that's a legal requirement. But most of the time you get no royalty because you have to assign your invention over to the company.
All right, thank you for answering this question too. Just a side note, Jay, my favorite artist is Noise MC. It's Russian hip hop and rock artist. Just so you know.
I don't know of particular Russian artists, but I would like to learn more about them. Authors maybe, artists not so many. I'm a kind of a nerdy scientist. I should be spending more time with art though. Maybe now that I'm.
Okay, so we have some more questions. How early should businesses worry about protecting their intellectual property?
Yeah, that's a great question. At the very start. And it's not so much worrying, but it's planning. So in the extra slides that I will be in the slide deck, I talk about, forming a strategy. So you're going to have a business strategy and you're going to have a business plan, right? You know, if you're going to start a business, you need a plan. Part of that plan should indicate which kind of intellectual property you're going to apply for each aspect of your business. So you're going to say, part of my plan is to come up with a name, and I'm going to register a trademark, and I'm going to develop a logo, and I'm going to register the trademark. And it's a product, and I'm going to apply for patent protection, or I'm not going to apply for patent protection. You need to make that decision. And then, are you creating something that might need copyrights? Or most importantly, are there aspects of your business that you are going to keep trade secret so that whenever you go to deal with other people to get funding or to employ people or something, that you're taking steps to protect those secrets, so that you've thought about it up ahead. And it doesn't cost a lot to think about it and plan. It only costs when you start implementing. And if you plan it out right, then you'll know when you're seeking funding how much money you're going to need. So you don't say, well, yeah, I got this great idea and I started, but oh, I forgot to get money for my patents. That's a bad position to be in.
All right, planning strategy comes first, especially when talking about patents. Thank you for clarifying that to us. Also, a question, what are some of the most common mistakes you see maybe in the businesses you work with that they do regarding the intellectual property?
I think the biggest mistake is they wait too long. So they, there might be a scientist in the business, and maybe he's an experienced scientist and he even has a few patents, but he figures, well, I know everything, I know what I need to know, and they wait too long to start getting their protection. I think that's the biggest one, and there's, they also didn't start early, and well, that's the same. They didn't start early enough. They don't have enough funds to protect. Maybe they're applying for something that they, in a country where they'll never be able to protect the intellectual property. Because remember, you have to actually take someone to court. And yeah, I can get a patent over in China, but am I really going to sue someone in China? That'll cost a lot of money. But then again, maybe I'm building a big business and actually my product's going to be manufactured in China, and I have funding. I have venture capitalists backing me. So yeah, I might want some protection in China. China's actually getting much better at protecting intellectual property. While the US is weakening our patent laws, China is strengthening them. And what's the outcome of that? More people are applying for patents in China. More people are starting their businesses in China, and they're not getting patents in the US as easily. So the balance of economic and science power will shift to the countries that have the protection for it. And if unless the U.S. government gets off its butt and strengthens our patent system again, we're going to lose prominence in it. So anyway, that's a little too political, perhaps, but I would say companies really need to just think about it when they start.
This is still a good idea of what we should think about before we're actually starting our business and going full in offense mode when we start our business. I have just one more kind of follow-up question to that. Have you ever witnessed the downfall of a business just because they failed to do something right with their IP? And can you describe that?
Well, I guess I don't have an example of a company that failed because of what they did wrong about their IP. I mean, companies get sued all the time by someone who thinks you're infringing. So even if you're not, companies will step forward, people will step forward and say, oh, I had a patent on what you're doing, and sue you. And maybe you did everything right, and so nothing happens. But what I have seen happen to companies is other companies copying their inventions, and especially independent inventors, and then the independent inventor not having any resource to stop them. And one of the it's an amusing product, but it's a very sad story. But he eventually won. There's this product called Bunch of Balloons, And the inventor is Josh Malone. So I'll type that. Josh Malone, not the football player. Bunch of balloons. And he invented this little thing that hooks up to the faucet and fills water balloons. A whole bunch of them all at once. And it's a fun toy. And he got a patent on it, and he got it on the market, and companies began to copy it. And so he had to go after them in court. And he continually was winning until one of those companies went and challenged the validity of his patents. And the Patent Trial and Appeal Board, the court took away his patent. They invalidated it for no real good reason. And he had to go to the federal courts to get his patents back. And so now his career, I mean, he made a lot of money on his product. His career now is fighting for inventor rights. And he even moved himself to Alexandria, Virginia, near the patent office, and established a company who fights for inventor rights. So the stories that entrepreneurs will face is defending their intellectual property once they get it.
Wow, it's a fascinating story. Thank you so much for sharing that. Let's come back to the questions from the chat. So Daniel asks, will the recording be available for download? Yes. If you would like us to send it to you via email, please share your email into the chat. Or if you don't want to share it into the chat, you can just go to Microsoft Teams and message me directly if you don't want everybody to see that. Also, if you want to get updates on our next meetings and the news of the club, also share your email. We would love to update you on what's going on. Nada asks, what are some issues associated with IPs and COVID-19?
What are some for COVID-19? There's a lot of intellectual property around, the whole pandemic, and there are companies that have developed tests for the virus, and all of these tests are a little bit different. And all of these companies have applied for patents on how their test works. But you don't need to have your patent granted in order to sell it, because it takes years to get a patent. But they're trying to protect theirs. The vaccines, all of the technology around making the vaccine, there's a lot of trade secrets involved. There are patents that have been filed on that technology. It turns out that the technology around RNA based vaccines has been around for a very long time. So the basic technology has been known for a long time. And fortunately, it's been known for a long time because that's what let companies jump on the bandwagon so fast to develop the vaccine. They didn't invent RNA vaccines so soon. They just hadn't developed them for any particular diseases. And this turned out to be just I don't want to say a golden opportunity for them. This turned out to be, very lucky for us that they knew how to do it. So you will see over the next years, as the patents begin to issue or publish and issue, you'll see lots of technology out there, which is good, because once you see that technology, then you have the ability to improve on it, because they can't stop you from making an improvement. They can only stop you from copying it. That's why the patents exist, because it shows the world, shows inventors what you've done, and gives them an opportunity to do it better. And that's what advances science. So we'll see even better vaccine technology invented, because it's not all being kept secret.
Thank you so much for answering my question, Bernard.
Sure. Then there's somebody's asking about a company that makes diamonds out of ashes. And do you protect the engineering, the shape of the diamond, the idea? Well, you can't protect the pure idea. It's a great question. But certainly the engineering that can cause that to come about. And let's think about it, right? You have to apply heat and pressure and for a certain length of time in a certain way. And to the extent that this information was never published before in textbooks, just knowing that it takes heat and pressure to make a diamond doesn't mean you can't get a patent on the method to do it. Plus, some of these diamonds are almost indistinguishable from real diamonds nowadays, right? They're flawless. They're just magnificent creations compared to some, early artificial diamonds, cubic zirconias and things from many, many years ago. These diamonds are really stellar. And so maybe there's even some trade secret information for the exact parameters that make it come out the way it does. But yeah, all of those engineering aspects would potentially patentable. But you have to make sure that it hasn't been done before, or that there aren't descriptions of all of the steps that it would be obvious to put them together to do what you've done. And that, as I said, is a more difficult aspect of understanding whether something's patentable. But a patent attorney or a patent agent would help you, figure that out before you filed an application.
Professor, thank you. Thank you so much for answering that question. And just my last question that comes with that. How can I make sure that that hasn't been done before? In the registration, do they help you find that out?
Well, you would want to do a patent search yourself to see what was out there. When you apply for a patent, the patent office will do a search and they'll tell you what they find. But before you spend the money writing an application, it's a good idea to know what's out there. And you have to be able to describe the invention with sufficient detail that someone else could actually make and use it. So that's why it can't just be an idea, because I might have an idea about how to do time travel, but I can't write that down and describe it in a way that someone else could travel through time. So it's got to be something that you could physically describe. So if you're a mechanical engineer and you have some data and you've done some experiments and you can show how much time and temperature and pressure and the shape of the mold or whatever the conditions are, and you put that in your patent application, then you might be able to get a patent on that. Now I see somebody posted a YouTube link in the thing, and one of the things I want to caution people about, the internet's a great place and there's a ton of information out there, but if you're looking for information about intellectual property, there are two things you got to be careful about. Two very important things. One, you need to know what the source of the information is. So in other words, is it a patent attorney or a patent agent, or is it just someone who has no legal training telling you what they think the law means? That's very dangerous. But people do that, right? Authors will tell you all about how to get a copyright. And people will tell you all about how to file a patent, but they're not really legally qualified to do that. The second thing is when was that information recorded? Even if it was an attorney, or if you find a book or a course online, then there's lots of good courses online too, some of which are free, taught by really, really smart people. And a lot of law firms give free seminars online all the time about patents and trademarks and copyrights. But when was that recorded? Because the law changes over time. And they may be giving you information that's 5 or 6 years old that no longer is applicable to your situation. So you can get some background, but you have to be careful, and you want a live person explaining what the current information is if you're going to move ahead.
All right, thank you. It's a really good info, Bernard. By the way, the link to the YouTube channel is EPDC. It's our YouTube channel where the recording will be posted in a week. So
all right.
I hope we can be considered a pretty credible source with you.
Well, you want people to know when, well, but you want people to know when was this recorded, right? And that's important, because 5 years from now, it's possible that a lot of what I said isn't true anymore. The law could have changed. It might get better, it might get worse for some things. And that's what's important. And thank you. I'm glad you sent me the link to your YouTube channel. I'm gonna click on it so I have it for later. I think it's really exciting that you guys. I think it's really exciting that you have an entrepreneurs group. You know, I visited the Bellevue College once, about now it's almost coming up on 2 years, because it wasn't last year during the pandemic, and I'm really impressed. It's such a wonderful place. There's so much going on there, and there's so much opportunity for people, and all of the students that I get, even though I get them online, are so enthusiastic, and so this is really very nice.
Thank you for those kind words, Bernard. We hope we can
Thank you.
campus too soon, honestly. Hopefully we'll be back in fall, at least for hybrid. Okay, we have another question in the chat. It's a little bit strange. Well, I didn't expect this question to show up, but basically Jay asks, how do communist governments impact IPs of businesses?
Actually, the Russia and the USSR and all of those countries have had patents for decades. Yeah, they have intellectual property laws. They do protect intellectual property. A question often that arises is are some governments less friendly to businesses outside the country? So, you know, China's a good example, where years ago, a US business had a very hard time establishing itself in China and had to give a portion of the business to the government, an interest in the business to the government to operate there. But that's changed a lot now. And with global trade, countries see the need for businesses to operate in their country. And the reason a business will operate in a country is if they can protect their investment. So the governments have to make it easy for people to set up a business and protect it, have a patent on their product or invention or something, so that it isn't copied. Because why would I go to a country, set up a business, start manufacturing and selling something, only to have the guy across the street from me manufacture and sell it for less than I do, right? But if the government in that country says, I can stop that person with my patent, then I'm going to go there. And the government says, that's great, because I'm going to pay taxes. I may have to give the government an interest in it. I'm going to employ people, right? There's going to be jobs, and people will make money, and the quality of life will go up there, and that's good for a country. So patents help countries, and patent laws help countries. They really do.
Thank you. So guys, we have about 5 minutes left, so please push on those questions. If you have any you want to ask, just feel free to put them into the chat. Oh, we just have one.
Yeah. Oh, what a wonderful question. Who asked that? I see. CRL, is that how you pronounce it? Okay, yeah, that's a great, valuing IP. So you value your intellectual property based on how much money it brings to your business. So if it's a trademark and people buy your product because they know it's from you as opposed to someone else, I mean, you can buy any number of brands of cola, right, to drink, but some people want Coke, some people want Pepsi. What's the value of the name Coke or Pepsi to Coke and Pepsi? It's billions of dollars, because people don't just buy cola. right? They know what they're buying. And if you have a trademark that identifies your product as the one people want, then that trademark is worth a lot of money. Now, what about a patent? Well, if your product is easy to copy or easy to work around, let's say you have a patent on your little widget that you're selling, but someone can make one that's similar that doesn't infringe your patent, maybe your patent isn't worth anything. And you want to decide up front, is it worth it? And patents are expensive to get. Trademarks are not as expensive to get. So maybe your product is all brand and no patent. You get out on the market really quick. And, like years ago, you're all too young to know, pet rocks were a big thing. There was no patent on a pet rock, but they made tons of money and then it went away, right? It was a fad. And there are a lot of products these days that you put it on the market, you sell a lot of it, and then maybe nobody ever cares about it again. But you made your money, so you don't need a patent. There are some things that will be obsolete by the time you get your patent. So it may be a feature on a cell phone that might be patentable, but by the time the next generation of cell phones comes out next week, and you're still waiting 2 years or 3 years for your patent, what good's the patent in 3 years? But if it's the fundamental technology that makes that next generation cell phone work, yeah, maybe that patent is worth a lot. So it's tough. It's how much money will it bring you is really, or how much money does it protect? What aspect of your business income does it protect? So the trade secret may protect all of it, right? It might. I don't think the trade secret of Coca-Cola protects anything because they tried to make Coke taste like Pepsi and nobody wanted it, and there's other colas that taste just like Coke, but no one wants them. So, yeah, I thought that's a great question.
All right. Any last minute questions? We have 1 minute left. Maybe last question anybody wants to ask before we wrap up the meeting. So I have a question. Well, maybe we'll receive one more. I have a question. So Bernard, if anybody wants to connect with you and find out more, and maybe they have some more questions after the meeting, where can they reach out to you?
Well, you can reach out to me at Bellevue College, right? You all have at I'm ELLEVUE BellevueCollege.edu, not com. And if you want to connect with me on LinkedIn, then you can find me there. But if you do reach out to connect with me, please put a message in the request so that I just go like, I don't know who this person is, and not connect. Just say, I'm a student at BC and I want to connect with you. And it's like, you bet, no problem. And I'm always happy to answer questions. Absolutely happy to do that.
All right.
Yeah, you'll find me on LinkedIn. You'll see my smiling face in my profile.
All
There
right.
it is. There it is. She found me already. Okay. That's me.
All right. Thank you so much, Bernard, for coming to our meeting today and sharing your knowledge and answering our question. It was really knowledgeable and valuable, and we're so grateful for you being here. Thank you so much.
Thank you very much.
Yeah, my pleasure. And, the best of luck with all of you in your ventures. And, as I said, if there's anything I can do to help any of you, just let me know.
All right, thank you. And thank you everybody for joining us. We have meetings weekly on Fridays at 3 p.m., same link all the time. Next week, we have an entrepreneur who will be talking about his invention and business that he's working on right now. His name is Braden Olson. He was also running for a position as a governor of Washington State. So pretty interesting guest. He'll be talking about the future of education and how his business implements gaming, combines gaming and education for the best benefit of his students. So it's going to be very interesting. So please, if you're interested and want to learn more about it, check up with us next week, same time, Friday, 3 p.m. We'll be happy to see you.
Thank you, everybody, for coming.
Thank you
Thank
so much.
you very much.
See you
Bye.
next
Have a great day.